I view inherent relationship jurisprudence as a legal framework arising from indigenous legal systems based on traditional indigenous knowledge. It's not to say that the non-indigenous legal system is invalid, but it doesn't come from our frames of reference. It doesn't come from our realities. It doesn't come from our historical existence since time immemorial. Now, we've had to advocate for our rights under that non-indigenous system for many centuries. But in advocating for those rights, it does not necessarily mean that we put aside our own inherent legal systems based on our own ties to lands and waters. Those legal systems are based on those inherent relationships, already existing relationships. Now, what we've had to do to preserve those during the onslaught of colonialism has been to package them into what is called customary rights and treaty reserved rights. Now, those are property rights in the non-indigenous legal system. We've had to do that because that's the only avenue they had to protect those rights. It didn't mean that people stopped thinking about inherent relationships. It didn't mean that people stopped engaging and discussing and living by those inherent relationships. It just meant that there was some protection within the non-indigenous legal system that could maintain some of those inherent relationships in what was called off-reservation. So the right to hunt, fish, and gather is an important right to maintain inherent relationships, even though they're not called that in the non-indigenous legal system. Over time, there's been efforts to erode those rights. In some ways, those have been strengthened, some have been weakened, but they still exist. And then also, many indigenous nations have entered into treaty relationships. You cite the indigenous version of the treaties often in relating to those treaties, which include protection of lands and waters and those relationships that have to be maintained. We don't look at those things from a traditional indigenous knowledge perspective as resources. When we talk about inherent relationship jurisprudence, we're talking about first tribes re-looking at their internal landscape, developing legal frameworks internally and establishing it, and then asserting it and advocating for it externally from that foundation. That foundation is key to inherent relationship jurisprudence. Whatever it's going to look like, it's got to be from that foundation. It can't be something that we seek permission to do. It's got something that we assert as a human right. Our very identity is tied to inherent relationships, and that's true in indigenous thinking. So why can't we uplift that as a human rights standard? Why can't we uplift that to a legal standard that's enforceable regarding customary rights and treaty reserved rights? Say all our relations in a ceremony or something, we literally mean that. And our relations extend beyond this human into the different animals, the rivers, the streams, the sky, the beings that live in all these places. Everything has a spirit. So how do we exemplify those relationships? And then when those things are attacked, how does it affect us? If you harvest a tree, it's just a question of whether or not you believe in environmental protections of trees. For us, that's hurting our relations. So we were always involved in selective harvesting, for example, from a traditional perspective. So how do we protect those relationships in terms of the legal system? So understanding that we have responsibilities and obligations rather than just rights. First challenge is it's not going to be easy. The first challenge is it's going to take a lot of work because it requires a reorientation, an indigenous just transition of your whole legal system, your whole government system. So that in and of itself is a huge task, and there's no quick fix. You can't just pass a resolution to do that. It requires some thinking. It will require probably some constitutional changes within tribes, and it requires some tribal code provisions that would have to develop regarding enforceability. And then from there, once they do that, then they have to assert it externally to an audience that is not necessarily receptive to it, because it's not an easy concept to get across to those not steeped in indigenous knowledge frame. So it's marrying up the pragmatism of the present with the hope of strengthening that pragmatism into the future. They need to start with their own internal frameworks. What are their internal frameworks in relation to their traditional indigenous knowledge. It kind of dovetails into another concept called indigenous just transition. How do they transition from the current situation, the status quo, something different that's based on their vision of the future that involves protecting their lands and waters and also protects the health and well-being of their peoples. And so finding out that path has to be a commitment that's made that's going to go beyond a 2-year term, a lot more than just infrastructure. It's really about transitioning their governmental and institutional frameworks internally first. That's the starting point. It's a lot